All right, hello everybody. I've got something for you today that I think you might enjoy. Recently, there was uh, just to give a little background, we've got Gavin Newsom, governor of California, His Tyrannical Highness, who recently basically promoted and then signed a law that makes certain types of satire illegal, based on the use of AI, so-called AI deepfakes, and yeah, it's one of those things where you actually had to pay attention to this because this is one of those places where courts could cut out another little chunk of our rights and take them away. Fortunately, as of now, it seems like the situation is in better than bad condition in the sense that most of the law has been struck down except for one small part. So, I've found a couple of articles that discuss this, and I figured we could just go look at these real quick and see what various news outlets are saying about this, and then also take a little bit of perspective from the founders about what to do about laws like this that are, either unconstitutional or, just something that the government shouldn't do in the first place, even if it were constitutional. And, the answer is not to wait for courts to solve the problem, because they often won't. So, let's look at some actual news sources to learn a little bit about what actually happened. Here we've got Politico. Judge blocks California deepfakes law that sparked Musk-Newsom row. Federal judge on Wednesday blocked a California measure restricting the use of digitally altered political deepfakes just 2 weeks after Gavin Newsom signed the bill into law. The suit was brought by Chris Coles, known as Mr. Reagan on Twitter, who sued to prevent the state from enforcing the law after posting an AI-generated video of a Harris campaign ad on the social media site. It is parody and is therefore protected. It's worth noting that the allowances for speech, especially speech against the government and other, what would you call them, public figures, is very broad. You can say a lot of things and still have it be within the law. One thing that is not so great about the way that this law was taken down is that the Judge Mendez carved out an exception for a, quote, not unduly burdensome, end of quotation, portion of the law that requires verbal disclosure of digitally altered content and audio-only recordings. That means that, for instance, an actor who can do a really good impression of someone might be under different regulatory requirements than someone who uses AI to recreate someone's voice. Newsom's spokesperson, Izzy Garden, says that the governor's office was confident the courts would uphold California's ability to regulate deepfakes. He is incorrect, I certainly hope. Here's the Our Democracy thing again. Everybody loves that. He says satire remains alive and well in California, but really this is a serious chilling effect. And the people who make these laws often minimize the chilling effect that these laws have. If you think that something that you're going to publish is going to get you into serious legal trouble, you usually refrain from printing it. That is, most people will. And these chilling effects are a real thing that have a real effect on real discourse. And having some, government mouthpiece minimize those effects is really just kind of sad to see. Over at CBS News, the article doesn't contain too much additional interesting stuff, but it does underline the fact that the Judge John A. Mendez said artificial intelligence and deepfakes pose significant risks. Now, from a libertarian perspective, from an anarchist perspective, from a classical liberal perspective, the government is not supposed to, quote-unquote, reduce or minimize or even evaluate risks for the people. That's not part of the job of the government, because it provides a gigantic moral hazard, namely that the government overestimates risks that it wants to promote action against, and minimize risks that it wants people to be forced to accept. You can probably think of a lot of different examples of this. COVID risk was one of them. The numbers that were coming out were all over the place. There was a huge amount of confusion as to what was actually meant. There was a huge amount of poor data practices in the data themselves, in the sense that people who whose vaccination status was not known, was assumed to be unvaccinated, things like that. Over at Forbes, we have a crucial quote from the judge. AB 2839 is unconstitutional because it lacks the narrow tailoring and least restrictive alternative that a content-based law requires under strict scrutiny. Just a quick reminder of what strict scrutiny is: a form of judicial review that courts use to determine the constitutionality of certain laws. It is the strongest, or it is one of the strongest, if not the strongest, level of scrutiny that that the courts can apply to a certain thing. And usually it's invoked in equal protection claims. That would be something like a 14th Amendment claim for freedom of speech against a state government. Basically, someone says, this violates my freedom of speech. Freedom of speech is one of the rights that is protected and can only be legal to restrict under the case of strict scrutiny. Now, that's not perfect. They give it the most. They give it the most examination, and they're most careful about it. But it's still not a perfect protection, so you have to watch out on that. And from a revolutionary wartime perspective, we have to understand that when the government usurps powers, that a nullification of the act is the rightful remedy. The states have the rights to nullify federal laws that are not pursuant for the states have the rights to nullify laws whether or not those laws are pursuant to the Constitution, and the federal government has to figure out a way to either make the case or whatever. But the other thing I wanted to get to here is this Roger Sherman quote: all acts of the Congress not warranted by the Constitution will be void. They're void now. Not void when the court says that they're void. They're void as soon as they're passed and as soon as there's an attempt to enforce them. To paraphrase Spooner, if these laws were valid until they were voided by a court, that would simply give the government the ability to make whatever laws it wants and remake them over and over again as soon as the courts declare them unconstitutional. So, as always, the solution is to refuse to enforce, or to for people who are outside of California, probably the most fun comes from breaking these kinds of laws. And so that would be another great form of civil disobedience. Basically, I don't live in California, but I'm going to post on every Californian website or Twitter account or whatever that I can find as many of these deepfakes as I can possibly find, produce, collect, whatever. So yeah, it's a good decision, not a great decision. It does leave a few cases where there will be chilling effects. It does leave certain requirements on speech which arguably shouldn't be there. The reminder for all of us is that when the government produces a law that it is not authorized to do, that you have the right to ignore it. And that is absolutely one of the founding principles of the United States, whether the government likes it or not. So, I hope you enjoyed this little look at First Amendment jurisprudence. Again, not better than bad result here from the courts, but still has some negatives to it. And of course, the people maintain and reserve the right to resist bad law regardless. Remember your Spooner, we didn't agree to the Constitution. So, with that, I say thanks for watching, thanks for listening. If you enjoy the content that I'm producing over here on this channel, I would, anything you can do to help, that would be appreciated. You know what to do. So have an excellent day, have an excellent weekend, and I will see you all next time.